Everyone, welcome back to my channel. I've been so busy with work, so I've not been able to bring you these videos. But anyway, this is the video where the judge basically says no to the acquittal of Derek. Listen to what he says.
To take care of this morning, first and foremost, is the defense motion for judgment of acquittal. Mr. Nelson.
Thank you, Your Honor. Your Honor, pursuant to our discussions yesterday in terms of the timeliness of this motion, at this point the defense moves pursuant to Minnesota Rule of Criminal Procedure 26.03, subdivision 18, paren 1, for a judgment of acquittal in this particular case. I'm sure that the court is very familiar with the legal standards applicable in this case. The court needs to view the evidence as presented in the light most favorable to the state. At this point, Your Honor, the defense submits that the state has failed to present sufficient evidence, even in the light most favorable to the state, to establish two of the principal issues or arguments in this particular case. The use of force and whether the use of force was reasonable, as well as the cause of death of Mr. Floyd. Starting first and foremost with the use of force, what the state has essentially done is provided 6 different opinions from various police officers or use of force experts, all of which seem to contradict themselves or each other. For example, Sergeant Pfluger testified, and Sergeant Pfluger and Jody Steiger, I would say, are the only two who have had a consistent opinion that the use of force became unreasonable at a point that Mr. Floyd ceased struggling. Mr. Zimmerman, or Lieutenant Zimmerman, had the opinion that even at the point of, that the force became unreasonable, use of force became unreasonable when Mr. Floyd was handcuffed. Chief Arredondo, I think, approached it from a different perspective because that was more of a civil employment standard and it was a violation of MPD policy versus a real statement in terms of the use of force. Ultimately, the two experts that the state has presented, Jody Steiger and Seth Stoughton, are two, they even disagreed with each other. So you have a myriad of inconsistent, complicated use of force opinions that really demonstrate the difficulty of establishing beyond a reasonable doubt that the use of force was objectively unreasonable, which is the standard under Graham versus Connor. While they all ultimately said it was objectively unreasonable at some point, the question is when did it become? And we have, again, 6 or 7 different opinions on that. In addition, Your Honor, in terms of the medical evidence, you again have, as the court is aware, the cause of death. It has to be proven beyond a reasonable doubt. You have the testimony of Drs. Tobin, Dr. Rich, and Dr. Smock, who ultimately testified as to, and Dr. Lindsay Thomas. Those 4 doctors ultimately concluded that it was an asphyxial death. However, the state likewise presented Dr. Baker's testimony, which in large part, while he declared it a homicide for medical purposes, which is not a statement of criminal obligations or the criminal standard, Dr. Baker suggested something much different, which was that Mr. Floyd's heart simply couldn't handle the stress of the circumstances. So, Your Honor, the state has essentially introduced doubt in the context of providing multiple opinions from multiple experts, all of which seem to contradict each other, and for that reason we would ask the state to, or excuse me, ask the court to grant the motion for judgment of acquittal.
I mean, that was quite self-explanatory. Looking at the judge, he's already made up his mind. So I think it's very obvious what he's thinking. But listen to what the prosecution says.
Okay. For the state?
People keep trying to find out what Derek is writing. He has to keep busy. He has to look, credible.
Thank you, Your Honor. The state opposes the defendant's motion for a judgment of acquittal. The evidence taken in the light most favorable to the state as we've presented it establishes all of the elements of all of the crimes charged and negates the defense of reasonable use of force. The issue is not whether there are inconsistencies, minor inconsistencies in what witnesses say. The issue is whether, taken as a whole, the state has proved its case. In terms of the force analysis, a reasonable force, there's no question that the witnesses who have testified have all opined that the defendant's force was objectively unreasonable. He was not trained to do this by the Minneapolis Police Department. He did not follow policy. He did not follow procedure. And the force that he exercised was unnecessary under the circumstances and simply continued on too long. As to the medical causation issue, Your Honor, the state has introduced evidence that, if believed by a reasonable jury, clearly established that the defendant's conduct was a causal factor in bringing about Mr. Floyd's death, through the pulmonologist, through Dr. Baker, through the other witnesses who've testified. And so taken as a whole, the state believes that it's established and will establish beyond a reasonable doubt that the defendant is guilty of all charges.
I believe that the judge had already made up his mind. He has a different job to the jury.
I'm going to deny the defense motion for judgment of acquittal. I would note the standard, unlike a jury which has to decide whether the case has been proven beyond a reasonable doubt, and in doing so must presume the defendant innocent. The court's duty at this point is to look at the evidence in a light most favorable to the state. And even when there are inconsistencies, major or minor, between witnesses, the jury is free to believe some and not the others. And when viewing a set of facts in a light most favorable to the state, they could give their greatest weight to those witnesses who establish that the use of force was unreasonable and that the cause of death was positional asphyxia or lack of oxygen, however the state wishes to characterize it, but most importantly that it was caused by the defendant. That is viewing the evidence in the light most favorable to the state. It is clear that that has been established, and so based on that standard, the motion for judgment of acquittal is denied.
So what do you think about what the judge has said? Some people actually think that Derek is definitely going to be convicted because of, the judge refusing an acquittal at this stage. But what it is in practice is the defense attorneys would normally make a request for an acquittal halfway through the trial. These requests are normally not granted. It doesn't mean that the person who is being tried ends up always being convicted, but we would have to wait and see how this goes. Do not forget to like, subscribe, and share, and I'll see you in my next one. Bye.